Welcome to Unit 3, Lesson 3 of the Introduction to American Law. This lesson is all about the three different types of torts. The three classifications of tort law are intentional torts, negligence, and strict liability. Let's dive right into these. But first, we should clarify what this term tortfeasor means, because we will use it throughout this lesson. The term tortfeasor means basically the person who commits a tort. So if I hit you, I am the tortfeasor because I committed the wrong against you. The first kind of tort is intentional torts. And just like that example I just gave, an intentional tort is when someone means to cause harm. So if I don't like you and I slap you across the face, that's an intentional tort. I mean to cause you harm, and I commit that wrongful act against you. The most classic example of an intentional tort is battery, which is when someone violates the sanctity of another person's body. Intentional torts are pretty straightforward, so we don't need to dive into those much deeper. The next type of tort is negligence. Negligence is much more difficult to determine, so we will spend a lot more time on negligence. Negligence basically means carelessness. The legal definition of carelessness is basically when someone fails to act with reasonable care. But when we dive into what reasonable care means, it gets a little more complicated. Specifically, legal scholars use the Hand formula, which is B is less than PL, which means the burden of an individual to act to prevent harm, when that is less than the probability of harm occurring and the impact of the harm that will occur, then an individual has acted negligently. So to repeat that, when the precautions an individual takes to prevent harm, so their burden to prevent harm, is less than the probability of an injury occurring, and the impact that an individual and the impact that an injury will have, then an individual has acted negligently. Another standard that legal scholars use to determine negligence is the reasonable person standard, which basically means if an individual does not act as a reasonable person would act under the same circumstances, then they have committed negligence. However, there are a few exceptions to the reasonable person standard. Make sure to consult your notes for those. One of them being that if an individual, the defendant in the case, is physically disabled, then that defendant must act as a physically disabled reasonable person would act under the same circumstances. And there are a few more clarifications on that standard outlined in your notes. Next, when we move into how a defendant would prove a negligence case, we come across some of the same things that we came across in the last unit with litigation for evidence that people can use. For instance, eyewitness testimony, expert witness testimony, and then evidence. However, there are a few specifics with evidence that we should clarify when it comes to proving negligence cases. One of them being evidence of a custom, meaning if you show evidence of how things typically are in a particular environment, then that goes to show what a reasonable person would do under the same circumstances, which shows that either the defendant could have acted reasonably, therefore not negligently, or with negligence in the same situation. Another type of evidence that comes to surface in negligence cases is evidence of statute violations. Statute violations are basically breaking the law. So if you show that the defendant has broken the law, you are showing that they acted negligently because the reasonable person, by that standard, a reasonable person would not break the law. When it comes to proving negligence in specific cases, we need to take these two rules into account, the but-for rule and the substantial factor standard. The but-for rule states that the tortfeasor is liable if the victim would not have been harmed but for the negligence of the tortfeasor. That basically means if the victim would have been harmed in another way, that it was not just the tortfeasor who harmed them, then the tortfeasor is not responsible for the harm that occurred to the victim. For instance, if an individual has a heart attack and dies 1 second before a distracted driver runs them over, then the distracted driver is not liable because that individual would have died anyway. However, according to the substantial factor standard, the tortfeasor is liable if his or her actions were a substantial factor in causing the victim to be harmed. In our scenario of the individual having a heart attack, by the substantial factor standard, if the individual maybe was having a minor heart attack, so they might not have necessarily died immediately, and our distracted driver ran them over, then the distracted driver played a substantial role in causing the victim to be harmed, so that distracted driver would be held responsible for negligence. It gets a little more complex when we take into account what if the victim is partially responsible for their harm. For instance, maybe a pedestrian isn't paying attention and they walk into the middle of a crosswalk and a distracted driver hits them. In this case, the plaintiff, who would be the pedestrian, is partially responsible for the harm that came to them because they unknowingly walked into the middle of a busy intersection, but the distracted driver is also responsible for the harm that came to the pedestrian. So in order to handle situations like this, we should consult the standards of contributory negligence or comparative negligence. Contributory negligence was mostly a standard of the past, and that said that if a plaintiff's negligence contributes to their own harm, then they are not eligible to recover damages. What this meant in our pedestrian example is that since the pedestrian was partially responsible for the harm that came to them, then the distracted driver does not owe them anything. However, in more modern times, court systems have adopted the standard of comparative negligence, meaning if the plaintiff's negligence plays a contribution, then they should compare the plaintiff's negligence to the defendant's negligence, and based on that determination, the defendant should be proportionally responsible for providing compensation. For instance, if a jury determines in our pedestrian example that the distracted driver is 60% responsible for the harm that came to the plaintiff, and the plaintiff is 40% responsible for the harm that came to the plaintiff, then the defendant should provide 60% of the compensation. In addition to this, if you've ever gone and taken maybe a martial arts class or went whitewater rafting or something like that, you probably had to sign a waiver. And what a waiver does is it allows an individual to assume the risk of the activity that they're participating in. What this does is it helps lower costs, like the tort tax that we discussed in the last lesson. It helps lower costs for suppliers, and it also cuts out unnecessary litigation that might occur from individuals suing negligent or not negligent parties offering services. Basically, what the assumption of risk does, what waivers do and releases, is they say that an individual in participating in the activity recognizes harm may come to them, and they will not pursue litigation. They will not pursue litigation if harm does come to them from the activity. Now we shall move into our third category of torts, and that is strict liability. This one's really interesting because it says that even if tortfeasors don't intend to hurt people, and even if they act without negligence, so with reasonable care, they can still be held responsible for injuries that occur to individuals. This might seem a little weird at first because if you don't try to hurt someone and you act in a way that wouldn't hurt someone, how can you still be held responsible for hurting someone? But if we look into it a little further, specifically through the lens of products liability, then it starts to become more clear. Products liability states that manufacturers are responsible for marketing defective products regardless of negligence or lack thereof. This means, for instance, if we look at it through the eyes of medication, some medications are marketed through television or through doctors' offices, and they find out later that these medications actually have severe negative side effects for individuals. In this case, the pharmaceutical companies who made these medications did not intend to hurt the patients who took these prescriptions, and they also probably acted with reasonable care, doing some studies ahead of time, yet still it turns out that their products might have been defective and caused issues for individuals. In this case, the manufacturer is held responsible even though they did not have intent or negligence to hurt an individual. When an individual proves their tort case and is awarded compensation for damages, there are a few different kinds of damages that they can receive compensation for. One of them being compensatory damages, which simply makes up for the specific harm that occurred. For instance, if someone intentionally smashes your windshield on your car, that would be an intentional tort, and you would receive compensation for compensatory damages, which would simply be they would repay the cost of your windshield and the repair. That would make up directly for the harm suffered from that specific instance. However, there is another damage that you would be eligible for as well, and that would be compensation for economic damages, because you probably wouldn't have been able to go to work that day because your windshield was broken and you aren't going to drive down the road with a smashed windshield. So you would be eligible for economic compensation, which means they would pay you back for the money you would have got if you had gone to work that day. Then let's stretch this example a little bit and say that you were scarred for life from this encounter with the person who smashed your windshield. You can also get compensation for non-economic damages. The most clear circumstance for getting non-economic damages would probably be pain and suffering. You've probably heard of this before, and maybe if you had shards of glass get stuck in your arm, then that could have been pretty painful, so the individual would compensate you for that pain and suffering. Finally, punitive damages are only awarded in 1 to 2% of cases. Normally, situations don't arise where punitive damages are eligible to be awarded. However, they do come up every now and then. Punitive damages are basically intended to punish tortfeasors who go beyond just negligence in the way they act. Punitive damages are awarded when an individual acts recklessly or intentionally maliciously, or they just have blatant disregard for individuals' well-being. Basically, it means they go above and beyond negligence in the way that they act, so the courts require them to pay punitive damages as extra punishment for their poor behavior. So in this lesson, we discussed the three types of torts: intentional torts, negligence, and strict liability. And we talked about specifics about each of those cases and closed out our study of tort law. In this unit, we discussed the basics of tort law, what torts are. We discussed the great tort debate that's currently going on in our society between tort reform and tort expansion, and the different types of torts that exist in our legal community.